The court will now take up the case of Fletcher versus the state. Counsel?
Good morning, Your Honors. I'm Barbara Becheris, representing Thomas Fletcher, and I'd like to reserve 5 minutes of my time. Thank you. Your Honors, this morning I'm going to start with the motion to dismiss issue rather than the merits of the brief. That just makes a little more sense to me to begin there. And I want to start with a couple of points that seem fairly straightforward. One is that the issues raised in the motion to dismiss could have been made in the trial court, could have been objected to, could have been preserved, and were not. And the motion to dismiss
well, but under the precedent, that would have, I mean, the trial court could have not granted, right?
The trial court would have had to rule on them, but the trial court could have had a fuller exposition of the issues, could have had a colloquy with the defendant, could have sought other input before making its ruling that would give this judge, this court, Your Honor, a better record on which to consider the kind of sweeping changes that the state is trying to accomplish in the motion to dismiss.
And I couldn't tell from the papers, but what's this defendant's current position on whether he wants this appeal to be going forward?
Mr. Fletcher wants the appeal decided on its merits and does not want additional proceedings.
Okay.
I mean,
is that in the record, or that's just based on your personal knowledge?
This is based on the fact that everything that I have filed in this court is in consultation with my client. I can't go further into conversations with him, okay. But you know, this court is aware that the court's precedent places counsel in a sort of unique position in cases like this, that I am certainly not going to advocate against Mr. Fletcher, but I'm also, I believe, charged with presenting argument regarding the propriety of the death sentence and whether it was imposed according to law.
But if I understood you correctly, you said that Mr. Fletcher wants the appeal to go forward and be decided on its merits.
That's correct. That is correct, Your Honor.
So, a notice of appeal has been filed. An appeal is pending in this case. What provision of our Constitution would give us jurisdiction to consider a death sentence that has not been appealed? Would you agree that no provision of our Constitution would do that?
What provision of the Constitution would let the court consider a death sentence that has not been appealed?
That's right.
I don't believe there is such a provision because...
Okay, so if we agree that Article 5, Section 3B requires automatic consideration of appeals to this court and not sentences of death, if we agree that it is the appeal that causes our jurisdiction to attach, then how can we arrive at a rule of law that requires us to act where there has been no appeal, where a defendant chooses not to appeal?
Because of the automatic review required by Section 921.141.
Okay, so you're saying that the only requirement for us to, if there is a requirement for us to review a sentence of death automatically, quote unquote, it is statutory and not constitutional in nature, and we should be addressing the statute as the source of that obligation.
Yes, the automatic review provision is found in statute. The Florida Constitution does not use that word. The Florida Constitution confers non-discretionary jurisdiction on this court, as do the court's own rules. The automatic provision comes from Section 921.141 and has been there ever since the post-Furman statute was enacted.
And thus it is your position that the statute, the legislature, removed from defendants their constitutional right to direct the course of litigation by filing or not filing an appeal.
No, Your Honor, I don't agree that that provision removes the defendant's constitutional right. I believe that provision appropriately balances the defendant's right to autonomy, the defendant's right to control aspects of the litigation, the defendant's right to set the goals of the litigation, with overriding and very important public interests in ensuring that the death penalty is imposed according to constitutional standards. So the defendant's rights are not ignored, but they are balanced against other interests. And that happens with the Sixth Amendment in a variety of contexts. There is no absolute right of a defendant to do virtually anything.
Well, fair enough. Can you cite a U.S. Supreme Court case that enshrines this balancing function of the legislature above that of the individual?
I wish I could point you to a single case that gave a good answer, Your Honor. I don't think I can, or I would have. What I can point to is substantial and extensive jurisprudence of the Supreme Court talking about both the Eighth Amendment and Sixth Amendment rights, and showing that those rights have to be flexible in certain contexts, showing that those rights are not absolute. For example, I'm trying to think of Martinez as the case that talked about the right to self-representation, which certainly is enshrined in the Sixth Amendment, but the right to self-representation on appeal is not absolute, because there are other important interests that allow the court to limit the defendant's autonomy when it comes to the course of an appeal. So when you look at those decisions in their entirety, I do think that it's accurate to say that the Sixth Amendment rights, the autonomy rights conferred by the Sixth Amendment, can be limited or balanced in certain ways when there are compelling interests to do so. And when you're talking about imposing a death penalty, the most final and unappealable of sanctions once it's been carried out, that is a compelling reason for slight limitations on the defendant's autonomy.
Just as a matter, though, of basic statutory interpretation, wouldn't we, to the extent that you could reasonably read the statute as not being a clear expression of the legislature wanting to override whatever autonomy interest might be, whatever constitutional right there might be, that we would read it as not making the appeal non-waivable, and sort of before we even decided this big constitutional question, sort of waited for the legislature to speak with more clarity? Because it seems like the text of the Constitution doesn't really support the idea that the appeal can't be waived. I think it might be a closer call on this automatic review, but to the extent that it talks about a notice of appeal, and to the extent that this could reasonably be read as just sort of alluding to the fact that there's non-discretionary jurisdiction, it seems like under the just basic canons that sort of caution courts against getting close to constitutional violations, whatever, even raising a constitutional question when you don't have to, why would we strain to kind of attribute to the legislature a meaning that the text doesn't seem to require?
Respectfully, Your Honor, I don't think it's straining at all. I think automatic has a meaning, and the legislature used that word for a reason, and it means exactly what it said. What the Constitution does is give the court non-discretionary jurisdiction. The Constitution doesn't speak to the other issues that you're alluding to. The legislature, when it enacted the statute after Furman, the replacement statute back in the 70s, included automatic review. And at the time, that was understood to mean non-waivable review. And that was done because review of sentences was seen as an essential part of avoiding the concerns with arbitrary and erratic imposition of the death penalty that had led to it being invalidated in the first place in Furman.
But the Supreme Court, at least in some places, has made very clear that this Eighth Amendment right is a right of individuals not to be subjected to violations of the Eighth Amendment. Isn't
Your
that
Honor,
true? I mean,
the
I
Eighth
can
Amendment is
show
a-
you.
You've used the exact language you're talking about. I know the quote, Your Honor, but there are also many, many quotes about the fundamental respect for humanity that underlies the Eighth Amendment, which is not limited to a single person. It is a broader concern that means that the imposition of the death penalty has to be done consistently.
But all those things are not inconsistent with it being an individual right. I just don't. I mean, all those other things that are said about it are entirely consistent with it being an individual right that is there to protect the right of particular individuals.
Yes.
And obviously that's you agree that's part of it.
That is absolutely part of it, Your Honor. I just don't agree that.
I think it's. I have trouble understanding how that individual right, like all these other individual rights in the Constitution that are waivable, why this one is this right of appeal is not waivable when all sorts of constitutional rights can be waived all the time, subject to some protections, and certainly to make sure that the waiver is knowing and that the person doing it is competent to make the waiver and all that.
Exactly, Your Honor. A personal right is waivable, but as the Singer opinion tells us, just because a right can be waived does not give the defendant the right to insist on the opposite of that right. So the defendant, for example, the defendant could waive his right to be free from cruel or unusual punishment, but he can't insist on being executed by being dragged through the town behind horses. That there are limits. And of course, I'm deliberately being extreme there, but there are limits on what a defendant can agree to, and there are limits on what a defendant can waive.
So if I understand your argument, then it is the statute that tells us what the balance is, and it is the statute that you're asking us to hang the weight of your argument on as the balance that struck in your hypo, how far we went in saying how much the individual can waive, we said in the statute. So let's do that. Let's go to 921-1415, and let's just engage with the text. The judgment of conviction and sentence of death shall be subject to automatic review by the Supreme Court of Florida, and disposition rendered within 2 years after the filing of a notice of appeal. Mm-hmm. Okay. It seems to me like your argument would be a lot stronger if the legislature had not purposefully included the words beginning "and disposition rendered within 2 years after the filing of a notice of appeal." Wouldn't you concede that the statute clearly contemplates that there will be an appeal, and that if there is no filing of a notice of appeal, the first part of that sentence doesn't operate?
I think, Your Honor, the statute and Florida's history in this area conflates or treats as indistinguishable the appeal and the review of the sentence.
Well, but I'm asking you to engage in the text with me,
yes.
not anything else.
Yes.
Would you concede that on the face of that text, if there's no notice to appeal, then there is no automatic review?
I wouldn't, Your Honor, because the automatic review requires the filing of a notice of appeal, and that's how it works in practice.
So you do concede that the automatic review does require that there be a notice of appeal filed. In other words, here's what I'm getting at. I don't think that the legislature strips away anything from the individual. You have this narrative about how the statute is meant to strike this balance by taking away certain constitutional rights that the individual has. The statute doesn't say anything about making our review automatic and displacing the requirement of an appeal. If, for example, no notice of appeal is filed, I don't know how this statute even applies.
Your Honor, respectfully, if I argued what you just said, then I spoke badly. I do not think that the automatic review provision strips away rights that the defendant has. I think the automatic review provision, coupled with the way it's been interpreted and applied in this court for years, protects the defendant's right to say what he wants but subjects the death sentence to review through the vehicle of an appeal. And that, to read the notice of appeal provision the way that I think you're reading it, basically strikes out the word automatic. You could take the word out of
How is that
Section
so?
9.
It just
because
means
you
that-
could because you could take the word out of it completely, and it would the statute would still do exactly what you're saying it does.
There I disagree with you. It's automatic in the sense that it's not going to a DCA. It's coming to us automatically.
But that happens if it says shall be reviewed by the Florida Supreme Court. You don't need the word automatic.
I'm not sure about that. Help me understand because it seems to me, going back to what Justice Muniz was saying earlier about avoiding constitutional questions, the principle of avoidance, I think my reading of the statute, or the reading of the statute that gives effect to the notice of appeal, has in its favor the fact that it avoids a serious constitutional question about whether this statute operates to remove a defendant's right to appeal or not.
I'm going to back up just a little bit, Your Honor. I want to go back to the language of the Constitution and the statute. The Constitution says this court shall hear appeals of death sentences. And then the statute says that death sentences shall be subject to automatic review by this court. It is not my position that strips away the defendant's right. Yes, there is some limitation on the defendant's right to completely waive any review of the death sentence, but that is compelled by other constitutional concerns. I don't think this court can avoid constitutional issues by treating the notice of appeal as determinative, because there would still be constitutional issues if you have a situation where a single court could accept a plea and a waiver of mitigation and sentence someone to death and have absolutely no review of the resulting sentence. I think that would go against everything the U.S. Supreme Court has said about review of death sentences for legality and to make sure that they are not imposed arbitrarily.
Counsel, is it essentially your position that the automatic review is almost separate from what we would consider an appeal? That the automatic review is this a constitutional sentence, and was everything followed? And the legislature's addition of the time frame and the notice of appeal is simply the vehicle on which that automatic review travels to us, that it's not necessarily talking about the same thing. Is that what you're saying? Is that the automatic review is something that we have to do as a matter of constitutional authority based on U.S. Supreme Court decisions or what have you, but the notice of appeal mechanism is how we do that?
I believe that's true, Your Honor. I believe that the notice of appeal is a procedural mechanism that starts the clock running on that review process. And
do you believe that if a notice of appeal was not filed, let's say it was an error, or let's say the defense attorney said, I'm not going to do it because my client doesn't want me to do it, that we could review the case?
I believe that this court would still have jurisdiction to hear the case. Yes.
How?
The automatic.
How does it come to us then? We then step in on what? On like a explain to me mechanically.
That's the problem, Your Honor. These rights depend on someone invoking them.
But let's. I don't think it's. I don't.
That's kind of the heart of the matter.
That's really the heart of the matter. I mean, I guess what I want you to do then, if that is your view, then help me understand how let's imagine your client decides, I would like for you not to file an appeal in my case. Mm-hmm. That is my instruction to you. I have a right to the assistance of counsel. You have assisted me ably. Do not file a further appeal. Mm-hmm. Are you saying then that counsel, help me locate counsel's obligation to nonetheless file the notice of appeal, or if you're saying counsel doesn't file the notice of appeal, how it is that our automatic review happens? Does it come to us on some sort of weird writ? How does it work?
No, it happens through the filing of a notice of appeal that's directed by the trial court based on this court's prior determinations that review of all death sentences is something that has to happen in this.
With some sort of like Anders analysis where the lawyer says, you know, I've considered my client's express instruction not to appeal this case, and nonetheless, because of this court's precedent, I am defying the wishes of my client and filing this appeal because it is automatic. Is that what it would look like?
No, Your Honor, I think it would look like what you have. I mean, there have been cases in the past where motions were filed to dismiss appeals where this court directed, no, we want adversarial briefing of this death sentence, and we need it because of the automatic review provision. And I just wanted to go back to that automatic review provision. The reading that I think is the correct reading of that term that gives full effect to the word automatic is consistent with every other jurisdiction that has maintained the death penalty. And it's consistent also with how the U.S. Supreme Court has viewed death penalty sentencing schemes ever since the post-Furman statutes were enacted. If you go back to the 1976 trilogy of Prophet, Gregg, and Jurek, upholding statutes from Florida, Georgia, and Texas, the court mentioned in each one of those that the death sentence was subject to some form of review by a court of statewide jurisdiction when it found that those death penalty sentencing schemes were constitutional. And so could the requirement have been crafted more specifically along the lines of what Justice Grosshans just described? It could have, and there are states that explicitly use procedures like that. But what Florida has done is said we have automatic review of death sentences. We've instructed counsel. This means that you need to provide on appeal adversarial briefing of the death sentence. And I think that when you get to that appellate stage, it's important to remember that the Sixth Amendment right is not absolute and becomes even less so at the appellate stage once there's been a conviction. Now, there are separate issues here, and there's a lot of overlap, which I hope I will get to, between the waiver of an appeal and waiver of mitigation. But certainly once you get to an appeal, the defendant who has been convicted, whether it's through a jury verdict or a guilty plea, has
Is there any case law that supports your notion that the individual right to waive an appeal is diminished by anything? That there, any case law that says that because of Eighth Amendment concerns or any other concerns that a defendant can be denied his right to waive the appeal, which has been recognized by the U.S. Supreme Court?
There's not that specifically, Your Honor, or we wouldn't be here. I mean, that is partly part of the conundrum that's before this court today. But there are many other contexts in which
would it satisfy the Eighth Amendment concerns if there was a procedural rule in place that provided for a review for fundamental error in cases where a defendant wanted to waive the appeal and required counsel to file a notice of appeal with the court, notifying the court that the defendant didn't want to make any argument on appeal and wanted to stand, but then allowed the court to conduct a review to make sure that the waiver is intelligent and there was no fundamental error? Would that satisfy both the Sixth Amendment concern and the Eighth Amendment concern?
I think what we have already, Your Honor, in Florida does that.
How does it when it forces a defendant to be subjected to an appeal that he or she does not want?
Because the case law from this court allows defendants to voice their wishes if they want to. And there certainly would be nothing restricting the court from even appointing counsel for that purpose. So far, it's been limited to allowing pro se briefs. When the defendant wants to file a brief in this court arguing in favor of the death sentence, that has been allowed. But the court has also said on numerous occasions we review death sentences for sufficiency and legality. At one point, that phrase also included proportionality, but since the decision in Lawrence, that is no longer an issue. But Lawrence didn't overrule the longstanding precedent that this court looks at sufficiency and legality of every death sentence. And so what you have is a system where counsel on appeal is allowed or required to make arguments pointing out potential deficiencies in the death sentence. The defendant is allowed to voice what he wants, if what he wants is a death sentence. And the court has an obligation to review every sentence for sufficiency and legality. And so that is the balancing of rights that this court has struck, and I don't think completely strips the defendant of his Sixth Amendment rights.
I'm curious about something, and it's not dispositive on the legal issues that are framed, but your argument seems to suggest that the Florida's death penalty scheme would be thrown into question on Eighth Amendment grounds if we were to apply the Sixth Amendment and say the defendant has a right to waive the appeal. I want you to explain the basis for that, so that the other side.
The basis for that, I think, goes back to the three cases I mentioned before, upholding the first wave of post-Furman death sentences, and is also found in the extensive case law from the Supreme Court talking about the need for individualized sentencing. For example, the responsibility to consider available mitigation, which doesn't mean forcing the defendant to present it. Mitigation can exist even in the state's case, and if it's there, the court has to consider it. So I would say that allowing the Sixth Amendment right to absolutely overcome
and how does
the Eighth Amendment.
How does that square with the fact that there is no federal constitutional right to an appeal at all?
There's no federal constitutional right to an appeal, but in death sentences, there's extensive precedent saying that review of death sentences is part of a constitutional statutory scheme. And so if this court completely gave precedence to the Sixth Amendment values, which are important, and I'm not denying them, but which can be limited in many other contexts, then I think that would call the constitutionality of the sentencing statute into question.
And can we kind of circle back to where we started? I mean, just to be honest, it seems like, in my opinion, your arguments are pretty weak on the merits, but there's also kind of an academic quality to this whole discussion if, in fact, your client wants there to be an appeal. And so, given sort of the significance of this issue, I mean, what do you perceive to be the options for this court? I mean, one is to just kind of take your word for that. Another possibility, I guess, would be to remand for some kind of, waiver hearing. I mean, is there anything else that the court should kind of have on its radar as a possible way of dealing with that issue?
Well, I think the court has already dealt with, in similar situations, just resolved the cases on the merits, rather than taking the invitation to make sweeping changes in the law based on a defendant's expression that he does not want an appeal. I'm not trying to avoid your question, but it's difficult for me to answer some of this because you're starting to touch on conversations I've had with Mr. Fletcher that I don't want to get too far into.
I guess though, but I mean, it seems it would be. I think it would be strange for the court to take this step in a case where, from you're telling us that he does want there to be an appeal, and so if we're open to reconsidering the question, it seems like that should be done in a case where the defendant, in fact, does not want there to be an appeal. And so my question is, what would be an appropriate way for us to verify what your client's actual wishes are here? Like I said, we could just take your word for it, but if we don't do that.
You could rely on me unless you have, some reason to question that I would be candid with the court, which I certainly hope you don't.
Well, we could also just rely on the filing of a notice of appeal, right?
The filing of a notice of appeal, which was acquiesced in. I will go that far. I mean, when the notice of appeal was discussed at trial, the trial counsel made clear that if the defendant were writing on a clean slate, he would not want an appeal. He did not want counsel
I guess my
appointed.
point is fair enough. So statutorily speaking, if we give effect to the filing of a notice of appeal, then that puts us on a trajectory that is reconcilable with the Sixth Amendment concerns. And I wonder why you're sort of fighting for a broader rule than that. Because, you know, if a notice of appeal has been filed, then we have before us that irrefutable expression of what to do, what the appellant wants in this case. I don't know why then you need to argue that we should, where no notice of appeal has been filed, nonetheless operate to override whatever the appellant wants because of some concern for Eighth Amendment reasons. That part, I don't know why you're stretching to that.
And I apologize again, Justice Curiel. That is not my position. My position is that in practice, when a death sentence is handled down, because of this court's precedent over years, the trial court directs the filing of a notice of appeal as a matter of course. It's a procedural, almost a ministerial task that happens. And I'm not envisioning a situation where courts would stop ordering that to happen.
Okay, counsel, you
And
have more than exhausted.
I've used up a lot of my rebuttal time.
Well, you used all your rebuttal time plus a minute, but I will nonetheless give you 5 minutes of rebuttal.
Thank you, Justice.
Good morning. May it please the court. Jennifer Davis on behalf of the state of Florida. I just want to touch on the statute for a moment.
Well, could we ask you to address this issue about the defendant's wishes? I mean, so what do you say to what counsel said, opposing counsel said about the defendant wanting the appeal to go forward, if I'm characterizing what she said accurately?
I think that we should have been notified if that was actually the appellant's wishes, because everything in the record and everything that he wrote to the court and to the judge himself said he wanted to waive an appeal. This is the first that I'm hearing. There is no notice. Otherwise, they would have notified me to dismiss that her client's position has changed. So this is news to me that his position has changed. And if the appeal wants to go forward, she's saying her client wants the appeal to go forward, then we can judge it on the merits.
Would you, it was suggested earlier that perhaps the best course is to remand the case back and have the defendant on the record saying what his wishes are today. Would you have any opposition to that?
I would not have any opposition to that. In fact, Chief Justice Kennedy, in one of your dissents in Robertson, you suggested the same thing. You thought that if a defendant wanted to waive his right to appeal, it was his fundamental right, and you even went as far as to say that it was a unjustifiable usurp of a criminal defendant's Sixth Amendment right to decide whether or not he wants to take an appeal, and you suggested to send it back to the trial court for a colloquy on the record so that it would be on the record that it was a knowing, intelligent, and voluntary waiver of his right to appeal. So I would not have an objection to that.
It sounded like before you got asked another question, though, that it sounded like you were willing to accept the representation from counsel about the defendant's current wishes, and on that basis withdraw your motion to dismiss. Did I mishear that?
I'm not withdrawing the motion to dismiss. I think it would be good to send it back if that is her. Honestly, I can't make that decision whether it goes back or not. But the state's position is that everything that we know from the record and what was said in court, that this appellant did not want an appeal. And that was the basis of us writing a motion to dismiss that has been on record since 2021. If her client's position had changed, I think she would have filed something to alert the state that her client's position had changed and we could just go forward on the merits of the appeal.
Do you recall what was filed in response to the motion to dismiss?
Yes, it was a response.
And
but-
the response opposed the motion to dismiss, correct?
Correct.
But it did not do so on grounds that
That the
that Mr.
appellant-
Fletcher wanted the appeal to proceed. Is that correct?
That is correct.
It was just because of, it was based on our prior precedent.
Correct.
Okay.
And part of my issue with the statute, she was talking that it's an automatic appeal. Automatic and mandatory is two different things. Automatic just means that those that receive the death sentence, this court has jurisdiction.
Counsel, what work then is the word automatic doing? Because the Constitution gives us that, correct?
Correct.
So why do you think, in fact, why would that entire subsection be necessary?
Because if a notice of appeal is filed in the case of a criminal defendant that's facing the death penalty, then it vests this court with automatic jurisdiction.
But we have that anyway, do we not?
Only if the appellant files a notice of appeal. If he doesn't file a notice of appeal, there is, as Justice Currier was saying, there's no vehicle to bring that appeal to this court.
Right, but the point is that Section 3B1 provides that when a notice of appeal is filed, it comes to us.
It says we shall have
We
jurisdiction.
shall have jurisdiction. So that's done.
So why?
But then then
Yeah, so why this provision in the statute then? What work is this provision doing when the Constitution already says when a notice of appeal is filed on a death sentence, it comes to us? What then is this doing?
I guess it's just enforcing what the Constitution is saying, that it shall come to this court if it's a sentence under death and there's an appeal in the case.
Right. So your view then for the state is just that this subsection is essentially codifying a constitutional provision in the statute.
Yes, to an extent. And I think...
Well, let me ask you, it goes beyond that. It says the judgment of conviction and the sentence of death shall be subject to automatic review by the Supreme Court. And the question is, if it's automatic and we're supposed to review the judgment of conviction and sentence of death, it doesn't say if a notice of appeal is filed, it just says it shall be. So doesn't that suggest that it happens whether or not a notice of appeal is filed?
Yes, and that's part of the state's issue with this particular case, that it conflicts with federal law and strips the defendant or an appellant of their Sixth Amendment right to autonomy.
So your argument is that the statute is unconstitutional.
I am arguing that to the extent that the Sixth Amendment does not allow a criminal defendant to not take an appeal in the state of Florida. We were just asking for a departure from Kuhn, Muhammad, and Morquat, only to the extent that it allows a criminal defendant to decide whether or not he wants to take an appeal.
And that's because Jones v. Barnes is correctly decided.
McCoy, Barnes, Garza, and also, again, Justice Kennedy in his
In
dissent.
Robertson. Okay. But before we go down that road, I think it's important to square up with the question you got from Justice Grosshans. The Constitution says we shall have jurisdiction over sentences of death. That means that our court has the authority to resolve cases and controversies about those things. The statute, you say, gives voice to that, specifies it, and the work, if I understand you right, that the word automatic is doing in that sentence is that it is detailing the path that a case comes to us by that is set forth in the Constitution. Am I hearing you right? Because I do think it's important to give effect to the word automatic. And I think it's a very important question for the state. We should hear the state's position on what the word automatic does and why it's there in the statute.
I believe that automatic, like I said, basically sends it from, it's something that happens naturally. Once I get convicted of a crime, I file a notice of appeal, this court has automatic jurisdiction. It just basically means it doesn't go to the third DCA, it doesn't go to any federal.
I mean, that's not what it says. It says there'll be automatic review of the judgment and conviction.
By this court,
Yeah.
yes.
So
But
for
we're
example,
not asking about the by this court part. We're talking about the automatic part. Automatic means without any other process, procedure, right? So
I agree, and I believe that's where the conflict comes in. There's different ways to interpret the Constitution and the statute, and this is not going to be, this is a type of issue that's capable of repetition. Appellate doesn't want to review, but because of the laws in our state, the Sixth Amendment right to autonomy is basically usurped and has to go through this process because that's the process that the state has in place.
So let's focus on automatic. Automatic generally means that some user input is no longer necessary. Automatic means some human is no longer exercising discretion. One way to read that is to say, well, the human whose discretion has been removed is the defendant's. The defendant has no right, or we're overriding the defendant's right to direct the appeal. That is one reading. Another way of reading it is the court doesn't have the ability to override it. That is, the court doesn't have discretion to not use the jurisdiction that the Constitution says we shall have in these cases. Is it the state's position that this court could decline to exercise the jurisdiction that it is given in 3B1 in any death penalty case, or does the state concede that we don't get that discretion?
Well, I concede that at this juncture, you don't get that discretion. And part of the issue is for those appellants that, or those defendants that do not want to take an appeal when they're facing the sentence of death, they do not have the right. Their rights are basically stripped away because of our automatic process that is in place.
Yeah, I mean, I think you're being, I mean, so I don't think that there's any reason for you to go along with the premise that anyone needs to sort of myopically focus on the word automatic. I mean, first of all, it says subject to automatic review. It doesn't say the Supreme Court shall automatically review. And it's also very reasonable to read this first part as just a setup for the real work that this provision is doing, which is giving us a 2-year deadline for rendering a decision. I mean, it's very reasonable to read the reference to the automatic, being subject to automatic review, combining that with a reference to a notice of appeal, is that it's basically just saying that if there's a notice of appeal filed, jurisdiction is in the Florida Supreme Court. And here's the new part, we're being told by the legislature to render our disposition within 2 years, which doesn't obviously appear in the Constitution. And so I don't think, it doesn't seem like it helps you to sort of adopt their kind of unnecessary reading of the statute and kind of force us to make this constitutional determination when there's a reasonable reading of the statute that allows us to avoid the constitutional question.
Okay. So would you like me to address the merits of the appeal? I can. All right. The trial court in this case meticulously complied with this court's requirement for a defendant who wanted to waive mitigation. The trial court complied with Kuhn and did a colloquy on the record. The trial court complied with Muhammad and ordered a comprehensive PSI. The trial court complied with Marquardt and appointed special counsel, independent special counsel in this case. The trial court did everything that this court required in order for a waiver of mitigation to be valid, and there is no error in this case. The record's clear that the appellant wanted to waive the mitigation. He signed a written waiver. There was the colloquy on the record. He wrote a letter to the judge and to the court detailing his crime, saying that he wanted to waive the mitigation. Basically to move things along. He did not cooperate with the Department of Corrections PSI, and he waived a Spencer hearing. So it's the state's position that it's a bit absurd now to fault the trial court for not developing further mitigation when in fact the appellate went out of his way to let everyone know that he didn't want the mitigation. So he waived his, it was a waiver of mitigation and almost an invited error. He can't, by his very conduct, create an error and then hope to benefit from that. And that's what this is in this case, because the record's clear what his position was on the waiver of mitigation. Also, by some chance, if this court finds that there's an error, it's a harmless error. This was a heavily mitigated case, mitigated murder. This was a capital felony that was...
heavily aggravated.
I'm sorry. Yes, thank you, I misspoke. Heavily aggravated murder. The capital felony was committed by a person that was already convicted of a felony and under sentence of imprisonment. The capital felony was committed by someone who had committed or been convicted of another capital felony or felony that involved threat of harm or violence to a person. This capital felony was heinous, atrocious, and cruel, and this capital felony was a homicide that was done in a cold, calculated, and premeditated manner. So, under those circumstances, this is a heavily aggravated murder, and the trial court got it right. Thank you.
Well, let me ask you this, counsel. You know, we have the merits here, which you've argued. Would I be wrong in thinking that the state's objective here is to get to the finality in this case as expeditiously as possible?
Yes, yes, Chief Justice. Nothing further. The state wishes that this court affirms the conviction and sentence. Thank you.
Your Honors, just a couple of points. I want to return briefly to just the fact that Sixth Amendment rights are not absolute and just mention some of the ways that Sixth Amendment rights can be limited or qualified. In pleading, the defendant can decide to accept a plea, but can be questioned about it and cannot force the state to give him a plea offer to a particular offense. And even after a negotiated plea, the court has to accept the plea. So that's one of the rights mentioned in Barnes and McCoy, and yet it is not absolute. There are other interests at work. Sorry. The right to counsel doesn't mean that you can compel the court to appoint counsel of your choice. The authority to waive a jury trial doesn't mean you can do so without the state's consent. So what we have here is an automatic review provision that, yes, does take away some control from the defendant. But as I think was mentioned during the state's argument, is more of a restriction on the court or a directive to the court saying you need to review certain types of sentences.
Counsel, you don't want to address the merits of the case?
I want to say something briefly, but I wanted to return to that because I think it's important, and I think the automatic review provision is crucial here. I also just wanted to note that Barnes and McCoy, talking about the right to forego an appeal or to take an appeal, did not involve a provision like the one that we have at issue here. And when you have every state that still maintains the death penalty having some form of review of the sentence, it would really call Florida's death penalty sentencing scheme into question if there were to be no review of a sentence simply because a defendant doesn't want an appeal. The defendant's not forced to appeal. The defendant can make his wishes known. The defendant controls what you hear on appeal by controlling what's presented in the trial court. So the defendant retains considerable autonomy in these cases.
Let me just take back to the conundrum that I think that we have. I mean, you've represented something, and it's not that we don't trust you or anything like that, but I mean, the way appeals work is that we're sort of bound by the record, and the record is clear that the defendant did not want the appeal, and when you had the opportunity to respond to a motion to dismiss, all you did was argue the law and our case law and why it should be upheld, and you still to this day haven't filed anything. So how could we do anything other than send it back for determination if we want to address that?
Because the record makes, I think what the record makes clear, Your Honor, is that the defendant understood what the law is and was acting within the parameters of the law in such a way that would resolve his case and give him the finality that he wants. And yes, if you look at the certain points in time, he expressed it in slightly different words. I can't find the record.
If you want to spend the rest of your time on the
Okay,
merits,
there was one place in the record, for example, where Mr. Fletcher said, in the future, I want to waive all the appeals that I can, clearly indicating that he understood that some review was non-waivable and other was not. What I wanted to say on the merits, Your Honors, is that yes, this was a heavily aggravated case, and we did not contest that in the appeal. The issue on appeal was limited to the reliance on outdated or at least stale mitigation and the failure to update that or conduct any inquiry into whether there was additional mitigation. I can't represent to you that there wasn't substantial mitigation considered, because there was substantial aggravation and substantial mitigation. So the issue before you is whether reliance on that mitigation from a previous case with no additional investigation, as summarized by special counsel, was sufficient to discharge the trial court's responsibility under this court's precedent. The issue is not more than that or less than that. So with that, Your Honors, I would just return to what Mr. Fletcher wants, which is for this case to be resolved. This court, as I said, in similar cases, has resolved the case on the merits without getting into the other issues of waiver of the appeal, and I think that would be what would be appropriate in this case as well. So if you have no other questions, I thank you very much.
Thank you, counsel. We thank both of you for your arguments in this case today. That's the last case on today's docket, so the court will now stand in recess.
All right.